A mistrial was declared in the Palisades Fire trial, okay? This is after the jurors told the judge they were hopelessly deadlocked. Jurors deliberated for about 13 hours over the course of 2 days, but they couldn't agree on if 30-year-old Jonathan Rinderknecht was guilty of causing the Palisades Fire, which was one of the worst disasters in Los Angeles history. In the final tally, 10 jurors voted for acquittal. There were 2 holdouts voting to convict. Rinderknecht had been charged in federal court with destruction of property by means of fire, arson affecting property used in interstate commerce, and timber set afire. He pleaded not guilty to all the charges. During the trial, prosecutors basically painted him as mentally unstable and angry at the wealthy. They read out Rinderknecht's alleged ChatGPT prompts and telling jurors that he used the platform to create images of fire and express his anger at the rich. That anger, they claim, is why well, according to their theory, he went on to this clearing overlooking the wealthy Pacific Palisades and started the Lockman fire using a lighter that police claimed they later found in his car. And prosecutors alleged it was that fire that smoldered underground for days before erupting into the Palisades Fire, which killed 12 and burned almost 7,000 structures in January of last year. But the defense fired back. Defense attorney Steve Haney pushed back on those claims, saying that Rinderknecht was at that clearing to watch fireworks since it was New Year's Eve, also pointing out that the fireworks could have been the cause for the fire. Also reminded jurors that computer activity doesn't equal arson. So after the mistrial, First Assistant U.S. Attorney Palisades responded almost immediately, posting on X, quote, "The evidence is strong that Jonathan Rinderknecht is responsible for igniting the fire on January 1st, 2025, which eventually became the Palisades Fire. We fully intend to retry this case before a new jury and obtain guilty verdicts on all charged counts." And the judge ordered Rinderknecht to remain in custody, scheduled a new trial that is tentatively set for October 19th. But I gotta say, I'm not sure another trial is really going to have a different outcome. After all, the jury was 10-2 in favor of acquittal, which isn't a great sign for the strength of the prosecution's case. You know who I want to talk about? Joining me now exclusively is the criminal defense attorney for Jonathan Rinderknecht, Steve Haney. Thank you so much for taking the time. So what's your reaction? How are you feeling? How is your client feeling? Do you see this as a win?
You know, anytime you get a 10-2 vote on a hung jury, you have to look at that and feel some satisfaction. Obviously, we would have preferred a full acquittal, but the 10-2 vote, it's my understanding, was the first vote as well. So it wasn't as if you had a real struggle with 6-6 or 8-4. It was pretty apparent that this jury had a real strong rebuke to the government's presentation over almost a 3-week trial.
And I'm curious what you think was missing from the prosecution's case. I'm going to play you something. So this was juror number 4, spoke about what transpired in the jury room outside the court today. She had this to say about the prosecution's holdover theory, meaning that the Lockman fire was held over and started the Palisades Fire. If we can play that real quick.
This holdover theory just wasn't it wasn't working for me. Like, how do you say that? Like, shouldn't the firemen shouldn't they have known? People were up there hiking and said that they saw smoldering.
There was reporting that a juror said, "I don't think there was enough evidence to say he started the fire, but say he did, I don't see why everybody else's negligence of doing things incorrectly where he needs to be responsible for the whole Palisades." What do you take away from that?
Well, I agree. The holdover theory was presented very briefly at trial. I think what happened is on cross-examination, one of the case agents contradicted the entire theory of the holdover, is that it was an undetected fire burning deep in the root system. And on cross-examination, he revealed that hikers saw smoldering visibly on the burn scar in the days after the fire. So you can't have a holdover fire and say that it's invisible and undetected when it's visibly smoking. And I know the civil attorneys in this case have addressed this as well. And, Jesse, we were not able at trial to even introduce the negligence of the fire department.
That's correct.
We had a free trial order.
By the way, if you were allowed to, do you think that would have had a different effect?
I think it would have been a not guilty maybe in 10 minutes. I mean, to be frank. I mean, the best defense was the superseding negligence of the fire department that we were not able to present. And that's fine. I'm not criticizing the reasons for that. The charging was done in a way that would prevent us from making that argument. And nonetheless, despite not having that ability, you got a 10-2 vote for acquittal. In my experience, you don't retry cases when there's a 10-2 vote for acquittal.
Let me ask you about that, because they're moving forward with that as of right now. What do you think kept the jury from a full acquittal? What were those two holdouts? What do you think it was? Do you think the two jurors, they were held up by the digital data that allegedly placed your client at the scene? Was it the testimony of Uber passengers who claimed that he was angry? Was it the green lighter that prosecutors say was used to ignite the fire and found in the car, or allegedly found in the car? What do you think the holdup was?
I don't know, but I would gather that it was the overwhelming mountain of state of mind or character evidence. All they did the entire trial for 3 weeks is engage in character assassination. And, you know, look, the U.S. attorneys were very good. They did a good job with what they had. But and I don't see this case being tried again and having a different outcome. And to be frank, I see an outcome on the second trial being a full acquittal. But I don't see how they're going to present anything different in a different manner when there's so many holes in this case. And I felt that way 10 months ago when I was engaged and got involved in this. I don't see this as a case that was even chargeable, to be frank.
Well, the two parts to that would be, then why is Assaili so quick to say there's going to be a retrial almost immediately? And two, if I'm understanding correctly, and correct me, and please tell me if I'm misspeaking, do you plan to do anything different in the second trial? You're going to do the same strategy?
Well, I mean, the strategy worked the first trial, and we had two people that, for some reason, I don't know why. I don't know what the reasons were, why they did not agree with the other 10 jurors, but I will do things better. I think the second trial, you can always reflect back, as you know, on a trial and do things differently or better, and the government probably would do the same. But I don't see that anything is going to materially change between this trial and the prior trial as it relates to reasonable doubt. There was just a mountain of it throughout the trial, and relying solely on state of mind and character assassination, that can backfire, and a lot of the jurors didn't like that. They didn't like the fact that they were picking on Jonathan about his loneliness, about his social ideologies, and I don't think in this country you should get prosecuted for what's in your mind. Thought prosecution is a dangerous thing, and I certainly don't think if you have a different ideology than somebody else, and I'm not saying I agreed with Jonathan's ideologies,
right,
but certainly he has a right in this country to have a different view of politics and life and not have that used against him, and replace that for arson evidence, which there is very little of, to be frank.
But before I let you go, got 20 seconds. How's he doing?
He's very encouraged that, the trial went the way that it did, and he's still in jail. I mean, he's still in custody, so he's obviously not happy about that, but I think overall, he's very happy with the way the trial went, and I think we were as well.
All right, well, listen, thanks so much for coming on. You got an open platform as this case potentially progresses to a retrial. Would love to have the conversation again with you. Steve Haney, thanks so much.
Thank you. Thank you, Justin.
Got it.
Take care.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.